6 minutes past 7, Tuesday mornings at Good Morning Scotland. Laura Maxwell is in Aberdeen this morning, Gary Robertson in Glasgow, and Laura will be talking about social care provision in the North East in this hour of the programme. But let's begin with a story that we brought you a little bit about in the last hour of the programme, where survivors of domestic abuse are calling for changes in the way that plea deals are handled in Scottish courts. Just after 8, we're going to speak to Liz Shanks, who was subjected to violent abuse at the hands of her former partner. She says she was less devastated in her dealings with the Crown Office, who dropped 7 charges against her abuser. So how does the Crown Office and the Procurator Fiscal Service decide on the best way to serve justice? Let's speak to Thomas Ross, KC, one of Scotland's most prominent defence advocates, who's with us now. Morning to you.
Good morning, Gary.
Thanks for speaking to us. And just give us an idea of the process here, if you will, before we get into the kind of the whys and wherefores. How common is it for the Crown to enter into some kind of plea arrangement?
I would say it's relatively common, and the idea is that every citizen has the absolute right to take every case to trial, because obviously the onus is on the prosecutor to prove the case. So if the accused person gives up his right to a trial and offers to plead guilty to something less than what he's charged with, then provided it's not a ridiculous offer, then the prosecution will require to consider it, because in the first place, it avoids the need for the victim to give evidence. And in the second, it may not really have very much impact upon the eventual sentence. So in short, if the prosecution think that the offer which is made will still attract a punishment which is appropriate to the crime, then they'll give it serious consideration.
And are there situations in these negotiations where a not guilty verdict may also be accepted?
That would be quite unusual. I mean, it does happen, but obviously by that stage a decision has been taken by the prosecutor to take up the case and proceed with it. So it would require quite unusual circumstances for the case to be abandoned completely. But, sometimes these circumstances come up. Sometimes the accused is already serving a very, very long sentence in relation to other crimes, and the views taken, well, it's unlikely that the sentence will be added to in any substantial way. So, for the sake of public resources, it makes sense just to walk away from it.
And if someone is facing multiple charges, then it could be the case that some of those may be dropped during this process too.
Yeah, I mean, the more charges there are, the more likely the process is likely to occur. I suppose, if I listen to Liz Shanks' example, and I understand how upset she is about the situation, but when there are multiple charges, there's obviously more scope in the general sense that they can depart from, 2 or 3 of the charges, and it will make very little difference to the sentence. I don't know what sentence it made in Liz Shanks' case, I'm sorry, but the more charges there are, the more scope there is for negotiation about abandoning charges.
Yeah, and we're going to hear from Liz again after 8 o'clock this morning. She installed security cameras around her home, and they captured some of the abuse that she faced at the hands of her former partner. Some of the charges were dropped, and she was unaware of this at the time. What can be done here to make things more transparent for victims?
Well, I listened to the piece, and we seem to be dealing with very reasonable people, so it seems to be that a solution can be found without the need to resort to legislation. There's a communication problem. Clearly, she should have been given a very full explanation as to exactly what happened, and it's a bit disturbing that even at this removed from the trial process, she still doesn't really understand it, and that's not her fault. It should have been explained by the lawyers who were involved in it. I mean, I don't have much doubt that there was a reason for it, and it may be that the view was taken that it wouldn't make very much difference in terms of sentence, but, I'm guessing. I don't know the circumstances. The reason I'm against making legislation is that these decisions often have to be taken at literally 5 minutes notice. The case is about to start. The victim might not be there because she's been told that she doesn't have to come to the second day of the trial or something. And, it could be that a very sensible way of resolving the case, which would help the victim and make really very little difference to sentence, would be obstructed if there was a statutory requirement essentially to stop the process. So I think in almost every case, if there was a protocol in place, the victim would be consulted. But I can envisage, the way that the courts are under siege, essentially with a huge backlog of cases, that sometimes time might not permit it.
Yeah, the suggestion seemed to be from the government that actually to put this into legislation would actually use up resources on the part of the court service, and as you say, a service that's already quite stretched.
It undoubtedly will, and the other slight concern I have is that everybody has to start somewhere, so you might start as a very, very young, inexperienced prosecutor, and there might be a very reasonable plea offer on the table. But if you have to, as a 25-year-old prosecutor, have to go and face a 50-year-old adult who may not be very pleased with the suggestion that a plea deal should be taken, the natural instinct is not to have the conversation, just to say, well, I know if I take it, I need to go and speak to the victim, so I'll just run the trial, with the result that public money and time and expense is occasioned and trials that don't need to happen.
Well, look, thank you very much for speaking to us this morning. That's Thomas Ross, KC, one of Scotland's most prominent defence advocates. As we say, we will hear from Liz Shanks after the news at 8.
It's 13 minutes past 7 now.